we've talked about the history a little bit, the intention, and then fast forward to 1974. Do we see that slide? The idea was to encourage fair trade across the world, and Congress recognized that the president should have the authority to do that because it was essentially it's a aspect of the president's conduct of foreign affairs. So in more modern times, President George W. Bush imposed tariffs on some steel products, but unfortunately, or fortunately, depending on how you look at it, those tariffs were lifted that year after an adverse ruling from the World Trade Organization. So then we fast forward to President Trump's first term. He imposed 25% tariff on steel, 10% tariff on aluminum products for a number of countries. The next year, there was negotiated the U.S.-Mexico Free Trade Agreement, U.S.-Mexico-Canada, I should say, and the tariffs were lifted as to those countries at that time. So we all know in the last few months, there's been a great deal of tariffs that have been enacted by the Trump administration. President Trump has described tariffs as one of the most beautiful words in the English dictionary, and that gives us an idea that we're going to continue to see tariffs, and that if tariffs impact our businesses, it's going to continue to be an impact that we need to see if there's anything we can do to guard against. Currently, today, the tariffs that are in place are, I'm not sure anybody knows. There's many that have been put in place. In January, there was announced a 25% tariff on imports from Canada and Mexico. A number of tariffs were implemented on April 2nd, so-called Liberation Day. Subsequently, tariffs were increased as to China for over 100%. And then many of those tariffs were suspended or postponed until July. The idea is currently the administration is negotiating with a number of countries, but the tariffs are expected to come back, at least as to many of those countries and for many of the products. So now that we know what tariffs are, what if anything can we do? The first thing to understand is to see if tariffs will indeed affect a job on which you're going to be doing bidding. And so you have to look at where products are being sourced from. Are they coming from countries where tariffs are being imposed? Are they products that are themselves subject to tariffs? And if they are, you want to get a hold of your supplier. If you have an ongoing relationship with your supplier, you want to find out if there's a possibility of locking in a price. Sometimes, buying products in advance is an option. Sometimes it's not an option. Looking at the idea of maybe substituting the foreign sourced products for domestic products is another option. Modifying your supply chain, assembling materials either off-site or on-site, and then obviously going with alternative materials. If it's a structure that can where you can modify the products, is that something that you can try to do? Obviously, you have to do that before the design phase. So once you've identified the risk, the important takeaway, I think, is notify your customer early so that they can raise issue with the owner and the owner can raise it with the lender. If you wait until the subcontract terms are being negotiated, it's typically too late. We've found that there are some owners that are indeed willing to assume the risk, but in order for that to happen, you need to contact the owner well in advance so that they can contact their lender, or if your customer is a general contractor, you need to give them time to try to work together with them to alleviate some of the risks that are going to come from the increases in tariffs. So there's going to be questions. Matt's going to talk a little bit about price escalation clauses and allowance clauses, and part of what feeds into that is how does one quantify the allocation of the increase in tariffs if you're not sure what the current tariff is, and it's difficult to know what the current tariff is. Are tariffs that are on the books but that have been suspended, are those tariffs that you need to guard against? If you have paid for materials from a foreign supplier, but they're not yet, they haven't yet reached the United States, and so the tariff has not yet been paid, you have to determine who has responsibility for paying the tariff. Sometimes that can be handled through either a letter of intent or a limited notice to proceed. If you can convince the folks up the chain, up the construction chain, to pay for materials in advance, but it's difficult to identify the supply chain because materials can originate in several different countries, and if the government determines at one point when the goods are purchased, or even when the tariff is paid, who's going to be paying for who's going to have the responsibility for the tariff, but then they later come back and say, well, no, actually, we've determined that the component parts from that particular good were sourced from another country, and therefore the tariffs are going to be different. You might end up having an issue with tariffs after the fact. So along with any time there's uncertainty, there's always going to be some people that take advantage of the situation. Sometimes you're going to have a price increase that's not directly attributable to the increase in a tariff, but it's going to be indirectly attributable. So if you've got a domestic supplier, for example, or even a supplier from a more favored foreign country with a lower tariff rate, it could be that they are going to have to increase their prices because some of the materials for the product that you're purchasing from them are component materials that are coming from other countries that have higher tariffs, or goods that are where a different tariff is imposed. So it's not just the direct effects of the tariff that you need to be concerned about, but it's the indirect effect. And then you're going to have issues where, for example, a domestic supplier of steel might raise prices because they're saying we have to get some of our raw materials from another country. They might say we are less efficient because we now have to produce more steel to satisfy the domestic need because foreign steel is not available, and so we have to charge you more for the even though it's domestic steel. So whether that's price gouging or whether that's a legitimate passing on of a tariff, it's hard to know. You're also going to have on the flip side of it is not just the increase in prices due to tariffs, but your customers may have problems, may have financial issues because of the tariffs, and the more broad-ranging economic uncertainty that results from tariffs. And so, the best advice we can give you is to pay attention to the provisions in your contract that relate to your ability to obtain payment from your customer, whether it's mechanic lien rights, avoiding pay if paid provisions, or maybe trying to have money payments put into escrow for increased prices on goods. Related government actions, directly or indirectly or separate from tariffs, are shortages of immigrant labor that can increase prices, general volatility in the economy. Last week, I was a little alarmed to see the Department of the Interior issue a stop work order on a mega offshore wind project right off New York that had a permit. So it wasn't an issue of saying we're not going to give you a permit. They had actually had a permit. Construction was in progress, and the Department of the Interior said we're going to revoke that. It makes make me a little paranoid about whether the government might do some of that going forward. So generally, with tariffs, there's going to be, in addition to the supply chain problems that we saw post-COVID, there's going to be issues of what are the tariffs in place, and so who's going to pay for the increase in the tariffs? And then we've talked about some of the indirect consequences. If you've got to store materials, you have additional freight charges, storage costs, and generally who's going to pay for the delay and the disruption that comes from all that. So with that, I'm going to give it to Matt to talk about the subcontract provisions, and then Michael will talk about what to do with your contract provisions.
Okay, so Jim, thanks very much for setting the groundwork for the new tariff environment that we're all going to be working through. I'd like to talk a little bit about contracts that you're going to be negotiating and writing in the new tariff environment that we are going to be working in now. And some of these issues are going to be similar to the issues that are in every contract, because every contract is trying to address the relationship between the parties and try to deal with uncertainties. It's just that now we do have a new source of uncertainty with the increase in tariffs and the way that increases in tariffs are going to interfere with the ability to get products and materials that are necessary for the performance of construction work. Right now, there is a little bit of a lull in the negotiation of contracts, because people are trying to figure out what exactly the circumstances are going to be and what their costs are going to be. And while there's been a lot of movement and new developments in the tariff area, and the ability of people to evaluate how the tariff is going to affect their project is still being determined, eventually we're going to have to get to a point where projects can't wait, that there is going to have to be negotiation of contracts to go and perform work in the real world. And so therefore the parties are going to have to move forward on a basis where they can make some provisions for performing work and also make provisions for unexpected or unknown circumstances that come up. So this slide is talking about how negotiation is the key. And the negotiation is not just what the terms are for the contracts that you are going to be negotiating, but also it's going to be negotiating about how the parties deal with changes and uncertainties and unknowns that become issues during the project. So you're not just negotiating what your what the contract price is and the duration and the scope, but you're also negotiating the processes that the parties are going to use in case there is an issue that arises in the performance of the work, like, for example, a increase in materials cost due to tariffs, or inability or difficulty in getting materials because the supply is constrained because the price of these materials has gone up, or other issues that arise in the performance of a contract. So when we're talking about negotiating contracts, we are looking for harmony. And so we have an attempt to balance the interests of getting the work done for the best price, but also getting terms that allow the parties to have a relationship to allow the work to be done for a fair price and having fair terms to address any issues that might arise in the performance of the work. And so the balance that's struck is a balance between having a contract with unfavorable terms, which increases the price, or favorable terms that decreases the price, and that these unfavorable terms can reach the point where the project becomes just impossible to perform for a reasonable price and the project doesn't go forward. This is going to the issue of how sometimes the contract that you don't enter into is perhaps the best contract because it saves you from being obligated to perform work that's going to be losing money. With regards to leverage is the various factors that the parties use to negotiate reasonable or at least acceptable prices. Owners are going to be able to negotiate on the basis of the fact that they are the ones who have the project and they are the ones who have the money. The golden rule is that the man or woman who has the money makes the rules. The subcontractors are going to, and general contractors to some extent, are going to have the countervailing issue to be able to present to the owner that the entire market is probably going to be changing in the sense that materials are going to be rising, materials costs are going to be rising throughout the area in which the subcontract is to be performed. Other subcontractors are going to be in the same situation, and so you're going to have less of a competition among subcontractors on price because price is going to be rising for everyone. But some of the issues that may be able to be negotiated are going to be the terms of the agreement that will be in effect between the owner and contractor and then contractor and subcontractor. The risk to the owner remains that if the project is bid too tight, if there's just not enough money allocated to the project, then you run the risk of having a project that encounters difficulties in performance because there's not enough money to pay for the work that is asked to be performed. And that leads to a project that ends up stalling or not getting completed, which is a bad which is a bad outcome for all parties, not just a subcontractor who is being asked to perform work for a price that is not going to be sufficient to allow the work to be performed. There are two main issues that we're going to be talking about today. There's the issues to be addressed are delays from untimely or unavailable materials. And that's going to be in part as an effect of the tariffs making materials more expensive and making the market tighter. And in fact, making it in some cases impossible to obtain sufficient materials due to the fact that materials are just not being shipped into the country and there's not enough productive capacity in the country to provide all the materials that are being sought. We have a situation where there are certain ships from China which are just not leaving because they have no certainty about what the cost of the products that they're going to be bringing in are going to be following the tariffs that are in place now and are expected to be in place when the goods reach the country. The other issue that we'll be talking about is increased costs from price escalation. The direct effect of a tariff is going to be that imported materials are going to cost more because there's going to be an additional tax imposed upon them. And so the cost of a material might be in excess of the amount that is estimated or agreed upon and at the time of bid. And then when it's time to actually purchase the material and install it, then the price is significantly larger, and that is ineffective to allow the work to be done at the originally bid price. So the first main issue that we'll be talking about is materials availability clauses. These include excusable delay or force majeure. And this is the type of provision that accounts for a factor beyond the control of a party that interferes with that party's ability to perform the work. The next issue is substitutions of materials. This is going to allow for the use of materials that aren't specified in the contract documents, but are more available. For example, if there is a domestic alternative that is equivalent or nearly equivalent to a now tariffed item, then that will allow the parties to use that substitution to perform the work. And then the idea of having a specific line item for supply chain delays and unavailability of materials, that is to allow the parties to directly account for the possibility and try to set some bounds around what the amounts of the change in the contract are going to be because of tariffs or other supply chain issues. With regard to force majeure, generally includes causes beyond a party's control. This can be unexpected long delivery because of unavailability of materials. This can be the simple unavailability of materials that are just not able to be obtained even on a long delivery basis. And then there is always the possibility of the owner or general contractor not providing selections in time to be able to allow the subcontractor to obtain the materials or otherwise be ready to perform the contract in a reasonable time. This usually, before modification, a force majeure provision will generally provide for an extension of time, but not an increase in cost. One of the things that we want to do is to modify the force majeure provision to allow for recovery of increased costs caused by the force majeure condition, in addition to contract time relief. And so we have next a modified sample contract language provision. This is adapted from the industry standard AIA force majeure provision. And the suggested new language is in bold in this section 3. So the subcontractor delay by unusual delay in any delivery arising from the inability to obtain materials in a timely fashion. And so also unreasonable increases in materials costs. So if the project is delayed, or if the subcontractor incurs additional costs because of increased materials costs, then there is an opportunity to obtain a remedy for the damages a subcontractor sustains as a result of the increase in costs or unavailability of materials. And then in the next to last line, there is that provision that allows for the contract sum to be increased in addition to an extension of the contract time to account for the fact that when a delay occurs, there's going to be a both a time impact, but also a cost impact, because time is money, and it's going to cost additional time for general conditions, for additional work to be performed by the subcontractor to either accommodate or catch up to the schedule delay, or other costs that are incurred as a result of trying to work around the force majeure condition. So the next issue is substitutions and design changes. So the idea behind this is to allow the parties to work through an issue that arises as a result of not being able to have the materials that are originally specified for the project. So the idea is to require the owner to use its best efforts to accommodate the availability of supplies, as opposed to simply insisting on full performance and exact performance of the contract documents, which is going to be unreasonably expensive, or perhaps even impossible if the materials are simply not available at all. So the remedial actions can include accepting substitutions that are reasonably close to the original design intent, and even consider alternative designs that will be able to make use of reasonably available products, as opposed to the materials that are no longer available. The sample contract language that we have here is an example, and that accounts for the ability of the parties to have a provision to account for delays in delivery or unreasonable cost increase. The parties should negotiate a number, if they are able to, with regard to what amounts will be appropriate for a cost increase. That's going to depend in part on the nature of the contract. If it is a lump sum contract, then the owner is going to take the position that the contractor should bear the risk of increases in price that are beyond the amount of the contract. The contractor and subcontractors are going to say that it is unreasonable to require them to accept that risk for a fixed amount, unless the amount of the contract sum, is increased to account for the possibility that there's going to be an increase in price. The subcontractor or contractor can protect themselves that way by giving a high price on a fixed price contract. But the countervailing tension is that there is going to be a possibility that another contractor or subcontractor will undercut that price and bear the risk of price increases. The problem with that is that the owner will either have the choice of picking a higher bid that's going to result in cost certainty and be reasonably expected to achieve the project, or take a lower bid and get the project for a lower price, but run the risk that there might be a subcontract failure because the materials are either not available or available only at a much higher cost, which will interfere with the performance of the contract, and in a severe case result in the contractor or subcontractor abandoning the project because they just can't afford to perform the work at a price of materials that is substantially higher than was contemplated in the bid. And so the purpose of this type of provision is to allow for a balancing of those tensions. The next issue that can be addressed with regard to materials availability is lead times. Obviously, part of being a contractor or subcontractor is being familiar with the lead times for the materials that are going to be necessary for the project. And the contract wants to have the requirements to allow for lead times to be incorporated in the project schedule, so that there are as few as possible delays resulting from materials availability. This sample language is to allow for the parties to have a process to adjust the schedule in case there is an unexpected occurrence of the situation where there is a delay, or that the contract schedule is simply not recognizing that there is insufficient time for the subcontractor to perform its work. And so the key provision is at the third line from the bottom. Upon the contractor's failure to adjust the schedule after 3 days notice from subcontractor, the contract time shall be extended to the extent subcontractor's project work was delayed. The key thing here is that the subcontractor is required to give notice of the inaccuracy in the project schedule and is entitled to relief if there is sufficient notice given and there's no remedial action taken by the contractor. The next issue is with regard to the schedule of values. The schedule of values can be adapted to allow for a particular contingency or allowance for supply chain issues, including delays caused by tariffs and unavailability of materials. This is going to have the opportunity to allow for an adjustment of the price of the work to match the ability of the parties to perform it in light of the difficulties that might be experienced. The sample contract language has the ellipsis in the second line to indicate that the parties should agree on what the conditions that will justify a contract sum increase to the extent of costs incurred as a result of the delay or tariff or other issue that's involved with the contract. And then again, also the delay allowance amount could be $10,000 and is just going to depend upon the project and its terms. Materials price escalation clauses. This is even more specifically directed at materials costs and addresses tariff issues. The triggering mechanism is going to be in the nature of a increase in cost. And so the parties want to have the ability to adjust the contract price when compared to a particular point in time, whether that's the time of the bid or the amount of the bid versus the amount of or the amount of cost at the time of purchasing the materials or otherwise. The idea being that there's some objective measure to be able to trigger this price escalation clause. The consequences and results should be clear. We want them to have a adjustment to the cost of materials, and if the parties agree, an adjustment in the overhead and profit or whatever other aspect of the cost escalation, the parties want to have that decided in advance. So 3 types of triggers include a threshold trigger where the prices rise or decrease compared to the amount bid, whether there's an index trigger where the price of materials compared to an index increased by a particular amount, and shared cost whereby the owner and the contractor and the subcontractor are recognizing that the economic conditions are uncertain, and so therefore it would be appropriate to share that risk among the various project participants. For example, some amounts that are used or price increases up to 3 or 5% are borne by the contractor. Price increases of 5% to say 20% are borne 50-50 between the owner and the contractor. And then price increases of 20% or higher are borne by the owner, with the idea or the rationale that the owner is the one ultimately getting the project and the beneficial use of the work, and so therefore should be responsible if the prices increase unreasonably to require that performance to be had. So I recognize that we're running a little bit light on time, so I want to go ahead and just call attention to some particular change order triggers. So the issue that I want to bring out here is that the sample language is going to address modifications of the contract sum, time of completion, or other contract requirements to be equitably adjusted to be when the price of an item increases by 20% or more. Another trigger includes recitation of particular items of the work that are going to be the key to triggering the performance and the ability to get a change order for the work that's going to be the subject of the clause. And then with regard to an index trigger, this particular sample language has a particular item of work that is identified, and then identifies an index that is going to be provided by a third party that is going to be used to measure the effect of the work that is going to be performed. And the key with that is that it is an independent third party that is measuring the effect of prices in the market. Another way to address this issue is to have a increase or decrease, or a two-way change order that will be more acceptable to owners, because owners will see that they will participate in price decreases to the extent any occur. And so won't be in just a one-way price increase. They'll also be able to obtain price decreases, similar to the lumber market had a large price increase, but then was followed by a large price decrease. Owners want to be able to participate in that decrease if possible. We've addressed other strategies through the discussion that we've had so far. The one item that I'd like to go ahead and just close on is the short time periods for accepting proposals can be based on the bids and supplier quotes that are going to be shorter duration because of the volatility of the market. And then early purchase of tariff threatened products may cost more and may incur additional costs to store, but are going to result in price certainty. So we've talked about the negotiation of contracts in the future. What remains is to have Michael Metz-Topodas talk about what to do with contracts that are in existence now and claims under them.
Excellent. Thank you, Matt. As soon as I can get capacity to share my screen. All right. You should be looking at something that says tariff-related claims. And while we're out there, so full disclosure, before becoming a lawyer, I was a teacher. So I'm really big into audience participation. So to rev us up in the last 8 minutes here, if you give me a thumbs up or a reaction or something, let me know you're still with me, folks. Because I want to dovetail off of Matt's excellent discussion about these contract terms. And a lot of you are saying to yourself, well, that's great, Michael. Fantastic that we know what to do with upcoming agreements. But what do we do if, unfortunately, we're in that situation? We're in a situation where, we are in a situation where we don't have a contract that has all the good things that Matt told us to put in them. What if we're in a situation where this was negotiated, before any of these tariff increases came into play and any of the price escalations and supply chain disruptions occurred? So in that situation, you're kind of facing an uphill battle, okay? Now you have to take a look then at what your contract actually says. If you have no price escalation provisions that Matt talked about and no supply chain issue supply chain clause provisions that Matt talked about, then you're in a tough spot. Maybe you've got one or the other, that's good. And of course, if for some reason you saw this coming and put it in your contract, beautiful, you're in a great situation. We'll actually talk about all three. I think we'll talk about actually the first and last. You can assume then that you'll have a hybrid solution with the middle there, okay? Most contracts, however, don't contain a price escalation clause. Most of them don't contain supply chain. And traditionally, right, price escalation and delivery delays have been borne by the subcontractor or the contractor, right? They've been considered the risk of doing business. You guys all know this. This is sort of what we face on a daily basis. And assuming, too, as well, that you may not have been in a situation, I think Matt and Jim alluded to, where as a subcontractor, for example, you may have been able to get payment for stored materials. You may have been able to buy out your contract earlier. But if you weren't able to do that, you can understand that perhaps some of your proposals from your material suppliers might be subject to price increases. And then what do you do upstream with your general contractors about trying to get those increased costs covered? Well, honestly, this situation, especially if you don't have those provisions about price escalation and supply chain disruption, puts you in a position of, in the proverbial football game, it's fourth and forever, 3 seconds on the clock. What do you do? And you're down by 6. You throw the proverbial Hail Mary pass, okay? And I understand I don't have the right images there, but you understand we've seen this time and time again. And every so often, those Hail Marys work. And quite honestly, I think our percentages are much better in this situation than what you might face, for example, were you in this actual hypothetical football situation that I described. So first thing you can do is check your force majeure clause, okay? Check it, see what it says. Typically, I think we know what force majeure is, unexpected event. Usually it says if some sort of unexpected event happens, then X happens. These clauses are not standardized. They sort of whatever the parties agree to. Very often they sort of were almost boilerplate before 2020, as we all remember. And then everybody started fiddling with them and adding words like pandemic, etc. You never know. You might have in that provision something that could be shoehorned into price escalation, supply chain disruption as a result of tariffs. I think we get this part. I think we already covered this. Now, the problem here is on force majeure clauses, though, is that in most states, most courts are going to construe those very narrowly because, of course, if it's an unforeseen event or act of God or what have you, that kind of ambiguity could give great disruption to what the contract actually means, and it might therefore allow for all kinds of dispute and uncertainty among the parties about what is or is not covered. And so as a result, courts take a strict view and say, listen, if it's not on the list, it's not there. So you might want to check that in your delay or time extension sections to see if you have anything. And there, for example, in the AIA, you've got something in there about unusual delay in deliveries. Now, Matt, I think, showed you a modified version. And of course, you can play with this any way you want going forward. But again, you're all telling me, hey, what about the contracts you already have? Of course. So you might be able to play upon the unusual delays in delivery. However, that really doesn't account for the price escalation, or at least you have to sort of make a chain of inference to get there, right? Unusual delays, then cause price increases, et cetera, perhaps. And as well, what does that mean, unusual delays? I think those words could be read in context to be unusual delays that result from a labor dispute, fire, unavoidable casualties, et cetera, adverse weather. So this isn't really the strongest language that you've got. You might also have something called a change in law clause. It's kind of like a force majeure, but it says if there's a change in law, then there's another trigger of what can happen. The problem, again, is what is a change in law and whether a change in the application of the law constitutes a change in law. So let me explain what I mean. This is just a random boilerplate language that I found out there, but it says due to any change in applicable law, regulation, or interpretation thereof. So there you've got the interpretation covered. You want to make sure that you have that. Here's the problem with the current tariffs. As I think we've discussed, those resulted from the federal government saying, we've got an emergency. We've got fentanyl coming through our border. We've got all kinds of other emergency situations that are requiring us to change our tariff policy. So there really hasn't been a change in law. Congress hasn't passed any new regulations. The president hasn't signed anything other than an executive order, which is really just a direction to apply the existing law. So as a result, you're going to get some pushback on your change of law provision, okay? So with no contractual support then, I think really I want to allude to what Matt talked about, and that is, hey, the project starts to become not viable for the parties involved. Certainly not viable for you all as subcontractors out there, because you're getting delays in supplies coming through. You might be facing liquidated damages charges or consequences or liability for the delay. You've got increased prices from your suppliers. They're all of a sudden, and I've had this happen, all kinds of clients, right? You get letters saying, oh, our prices have changed. I'm sorry. I know we agreed to before, but it is what it is. And so as a result, everybody is going to suffer, and the project runs the risk of no longer being viable, and you might be more economically efficient just to walk away. And what's the owner going to do? Try to hire somebody else? Well, you know what? They're going to be facing the same price increases, and then they have to then wait a few years to try to pursue those increases from those contractors who abandoned the project. So instead of all that nonsense and rigmarole, and I know it's 1 o'clock, we had a 5-part plan for how to deal with this, okay? Written notice to the owner, offer to collaborate, propose revised pricing, request shared responsibility, and seek a meeting. Let me explain to you how that all works. What you're going to want to do in this situation, your Hail Mary is a letter to the general contractor. For some general contractors out there, a letter to your owner. It's going to cover all 5 of those points, all right? So the first thing you're going to say is, hey, listen, we've had all kinds of price escalation, material supply chain delay due to implemented tariffs, okay? Give some facts and figures, find something off the internet, etc. Do what you got to do, but at least shake up their attention. Say, hey, wait a second. We go on and on about this, but let's, instead of fighting over this, let's talk about a solution, okay? So you say, listen, we're reaching out, right? We want to collaborate. We want to make sure this project can work. And similar to what we did during COVID, let's all work together to find a solution, okay? Then I'll offer some revised price tracking. Hey, listen, when it comes to supply chain issues and, of course, pricing, let's tag it to some indexes here, et cetera, the way Matt suggested in some of the contractual provisions, or offer any kind of other pricing adjustments, and then offer to share in the costs. I think, too, you can talk about that increase and decrease in pricing and make sure that I've definitely talked with other contractors and clients out there who are talking about the idea of, listen, I'll just pass along my cost to you, whether it's the subcontractor saying to the GC saying that to the owner, and it'll all be at cost and we'll all share in the pain together. Or maybe I absorb a certain percentage up front, similar to what would happen in a normal situation of where the risk is borne by the subcontractor. So then you get a meeting to discuss, because this isn't going to, don't do a letter back and forth. The letter campaign will take too long. Sit down face to face if you can, or over the phone, depending on the project. And then make sure, of course, have your counsel present, and see if you can work out a modification to your existing agreement. It might even require, similar to, I don't know if you guys have ever done any kind of integrated project delivery, where all the parties, owner, GC, subs, are all in a room together working off of one agreement. That also might be a possibility for this meeting here, okay? So that's your Hail Mary. That's what you do if you didn't do all the smart things that Matt was talking about in his contract. If you did, however, okay, if you did, and you are facing price escalations, same rules apply. I'll do this in about 90 seconds, all right? 3 key elements: preserve your claim, prepare your claim, and present your claim. Preserving your claim, check your notice in your contract. Make sure that you have offered alternatives and substitutions so that you're fulfilling your mitigation obligations, excuse me. Watch out for waivers. Some of you guys know this, right? Don't ever sign a lien waiver if you got a pending claim, because then you've just released that claim. Make sure there's an exception in that language. If you have to get paid and the owner's not letting you modify the lien waivers, call your counsel. Okay, there's ways around that as well. Keep your proper documentation. So you got to do 2 things, remember, right? You got to track your costs, both in terms of the delay costs that you're facing from supply chain disruptions, and of course keeping track of increased prices, and then make sure that's documented in real time, okay? Whether you're recording, certain time period delays, storing any of the communications and emails you'll be receiving related to these issues. I don't know what you got to do. Every situation is different. They're like snowflakes. Again, check with your counsel about how best to do that, because the more you keep those documents, organized and recorded, the easier it is to bring the claim. Otherwise, you're just going to spend more money on counsel fees at the end of the project and litigation, which I can tell you about, trying to present your case going forward. So do it at the outset. It saves money, and it also allows you then to go after smaller claims because your legal fees are less. Preparing the claim, right? Collect all your documents, etc. Put everything together in either a claim letter or whatever the contract requires. Usually, I think we know the process in AIA. There might be a neutral or a decision maker, an initial decision maker, excuse me. And then presenting the claim, again, that's that process I'm talking about. Whatever the contract talks about. Some have a claim meeting, some have a submission initial decision maker, that's AIA. There might be a project neutral, there might be a requirement for arbitration, and then some sort of litigation or arbitration at the end, depending upon what the contract says. But again, make sure you go through this process. As some of you living in Virginia or working in Virginia know, if you don't, you could be sunk because a lot of them contain waiver provisions. Failure to present a proper claim means the claim is waived, etc. You get all that. So make sure you protect yourself in all the ways that we've talked about. As I said, I practice in Philadelphia, so I'm going to turn to our favorite Philadelphia, Mr. Ben Franklin. By failing to prepare, you are preparing to fail. I hope all this has been informative. Thank you so much for hanging with us for 4 minutes extra. You'll get the slides later on, and if you have any questions, by all means, do not hesitate to reach out to Jim, myself, Mr. Bryant, any of us at any time. As you can tell, since we went 5 minutes over, we love talking about this stuff, and we love helping out subcontractors like you. And I look forward to hopefully getting to SubXL again and maybe meeting some of you in person. Thank you so much, everybody.
Okay, thank you very much for your presentation. Again, we will have this presentation up on the ASA online website, and we will also make the slides available to you as well. So we look forward to everyone joining us on our next ASA webinar. And again, thank you, gentlemen. Everybody have a great rest of your day.
Thanks, Jessica. Take care, everybody.
Thanks, everyone.